Welcome, friends. We have started this channel called Corporate Laws Galaxy. You know, galaxy means group of stars, and every star represents different laws. And we are starting with a series on frequently asked questions on very interesting topics of corporate laws. And we are inviting you, all of you, to also send your queries in our comments column in our video, and we will certainly take up those queries also in our videos. And now I will request you to please share, like, and subscribe to our channel. Thank you so much.
Namaskar.
Sir, I have come across some frequently asked questions from our professional colleagues regarding SEBI substantial acquisition of shares and takeover regulations 2011, which are popularly known as SAST regulations 2011. In this context, sir, could you please explain us as to what are the threshold limits for acquisition of shares or voting rights, beyond which an obligation to make an mandatory open offer is triggered?
Yes, sure. Why not? You see, as per Regulation 3 of SAST Regulations 2011, there are two threshold limits which triggers the obligation to make a mandatory open offer. As per Regulation 3, sub-regulation of SAST Regulations 2011, an acquirer who, along with persons acting in concert, if any, holds less than 25% shares or voting rights in a target company and agrees to acquire shares which, along with his persons acting in concert, existing shareholding, would entitle him to exercise 25% or more shares or voting rights in a target company, will require to make an open offer before acquiring such additional shares. As per Regulation 3 Sub-Rule 2 of SAST Regulations 2011, an acquirer who, along with persons acting in concert, if any, holds 25% or more, but less than the maximum permissible non-public shareholding in a target company, can acquire additional shares in the target company as would entitle him to exercise more than 5% of the voting rights in any financial year ending as on March 31st, only after making an open offer. To clarify more, we will have to refer to Regulation 7, Sub-Regulation 1 of the SAST Regulations 2011, which states that where the open offer for acquiring shares to be made by the acquirer and persons acting in concert with him under Regulation 3, the open offer shall be for at least 26% of total shares of the target company.
Okay, sir. Thank you for explaining it so nicely. Moving further, sir, for the benefit of our audience, could you please explain as to what is voluntary open offer?
Okay, sure. Let me explain to you as to what is a voluntary open offer. A voluntary open offer under Regulation 6 is an offer made by a person himself or through persons acting in concert, if any, holds 25% or more shares or voting rights in the target company but less than the maximum permissible non-public shareholding limit. Now, after what differentiates an open voluntary offer from a mandatory open offer is the offer size. That is, as per Regulation 7, sub-regulation 2, the open offer made under Regulation 6, that is voluntary open offer, shall be for acquisition of at least such number of shares as would entitle the holder thereof to an additional 10% of the voting rights in the target company. So, the offer size in mandatory open offer will be minimum 26%, and in case of open offer it will be 10%.
What a clear explanation. Sir, do all acquisition of shares in excess of the prescribed limit and or control lead to an open offer?
No. In respect of certain acquisitions, Regulation 10 of SAST regulation provide exemptions from the requirement of making an open offer subject to certain conditions being fulfilled. For example, acquisition pursuant to inter-se transfer of shares between certain categories of shareholders, acquisition in the ordinary course of business by entities like underwriter registered with SEBI, stock brokers, merchant bankers acting as a stabilizing agent, scheduled commercial bank acting as an escrow agent, etc.
Okay, sir. One more question. Whether SEBI has the power to grant exemptions to an acquirer from seeking an open offer or granting relaxation from the strict compliances with prescribed provisions of the open offer process, even if the proposed acquisition of shares or control is not covered under the exemptions prescribed in SAST Regulations 2011.
Yes, definitely. As per Regulation 11 of SAST Regulations 2011, in the interest of the securities market, upon an application made by the acquirer, SEBI has the power to grant exemption from the requirements of making an open offer or grant a relaxation from strict compliance with prescribed provision of the open offer process. But before undertaking such acquisition, SEBI may, at its discretion, refer the application to a panel of experts constituted by SEBI. The orders passed in such matters would be uploaded on SEBI's website.
Okay, sir. This brings us to our last segment. Now, we come to our last segment, that is adjudication of penalties under section 454 of Companies Act 2013. Sir, please tell us any latest case where Register of Companies has adjudicated penalties?
Yes, why not? Under the section 454, Registrar of Companies is authorized to act as adjudicating authority to adjudicate penalty in case of violation of certain sections of Companies Act 2013. In the case of Vidyut Tech Services Private Limited, the company had violated the proviso to section 42 of the Companies Act at two distinct instances which constitute a separate analyzed individually. Hence, Registrar of Companies, Karnataka, White Order dated 25th May 23, imposed a penalty for each default of rupees 2 lakh on company and rupees 1 lakh each on directors for violation of Section 42 of Companies Act 2013, that is, relating to provision regarding offer or invitation for subscription of securities on private placement basis.
Okay, sir.
So, thank you, our audience. We'll meet again. Bye.